I'm Donna Atherton. I am with the ARC Minnesota. I am specifically the West Central Regional Quality Council Coordinator. And one of the things we do is take a look at the systems that are in place and see what best practices are, what the needs are for people, and try to build things around that. Our funding comes from the Department of Human Services and the state legislature. And one of the work groups we have two work groups, two basic work groups that we do just at the West Central region. One of them is employment, and the other one is transition to adulthood. So that's why we're here tonight. If you have any desire to go further with some of the information that we're sharing, we have videos on employment, we have lots of resources. Please go to our website and I will put that in the chat. Tonight, we are very fortunate to have Anita Raymond with us from the Volunteers of America, who is very knowledgeable about supported decision-making and the alternatives there. And I think this is great information for folks. Sometimes people think that guardianship is the only option for things, and there are other things that can be considered that can be less restrictive for folks. So there you go, Anita, take it away.
Wonderful. Thank you, Donna. Thanks so much for having me. And let's all thank Donna for all her work in making this come to fruition tonight. So I appreciate that. I would love to hear who is here. And I'd also love to encourage you, since we are a smaller group, if you have questions as we go along, I will try to watch for if you do a hand raise. I think we could do hand raises here. If you turn on your camera, whatever way to put it in the chat or the Q&A, and maybe Donna can help me keep an eye on that. Sometimes I forget to look at some of those. But I do want to really encourage people to get the most out of this. I have prepared a formal presentation and trying to cover guardianship, supported decision-making, less restrictive alternatives. We'll talk a little bit about conservatorship and so forth. But I would also really like to know who is here. And I do see the chat lighting up with information Donna put in. Who's here? Professionals, parents of young people with disabilities? Tell me a little bit more about who's here and what your interest is, either by turning on your microphone or adding to the chat.
Hi, I'm Cindy Zander. I am a teacher here in Barnesville, Minnesota. Oh, let me put on my camera. There you go.
Wonderful. Thank you. Hi, Cindy.
You're welcome. Yeah, I'm a DCD teacher here in Barnesville, and I have been teaching for 18 years now.
Help me with the acronym DCD.
Oh, the developmental cognitive delay.
Got it. Thank you so much. I come with my own acronyms, and I thank you. Appreciate that.
Yeah, no problem.
Jenny. Whoops, we need your microphone on. There we go.
I'm Jennifer Wellman. I partner with Hubbard County DAC with the CREATE program. I'm a community partner with PREETs primarily, some vocational rehab services. And the reason that I'm here today is to learn more about some of the students that I have are transitioning from high school to vocational rehab to also community independence. And that's really what I want to learn about today.
Awesome. Cool. Thank you. Hopefully we'll give you what you're looking for. I see Judy turned their camera on. Hi, Judy.
Hello.
Whoops, did we lose Judy? Oh, there you, okay. Okay, so your microphone went back to mute. Was there anything else you were going to share with us? It's okay if not.
We're introducing ourselves, Judy Marie, and telling, well, I know that you're a parent, so that sort of thing.
Okay, that's okay. Anybody else want to share? So we've got parents, we've got professionals. in special ed and voc rehab? Oh, there you are.
For me.
Hey there, my name's Marissa,
Go ahead,
and
Marissa.
I'm sorry, I think I cut somebody off, but my name's Marissa. I'm going to stay off camera because I'm multitasking here tonight.
Sure.
But I'm here as a parent of a brand new 18-year-old, and also I work for the ARC as a regional community coordinator.
Excellent. Very good. Thank you. Welcome. So a few different hats you're wearing. Anyone else?
Anyone else?
I see Vicky. I see Judy still. I'm going to pause and give you the floor, Judy. Anything else you want to say?
I'm just a member of the Metro Regional Council, and I'm a mom of a son who's 34 now.
Okay, excellent. Thank you. Thanks for sharing. Vicky, did you want to share?
Sure. I am a mother of a daughter who is going to be 18 next August. So I figured I better get started figuring out what I need to do.
What you need to do, what the options are. Great. Glad you're here. Anyone else want to share?
Right.
Didn't mean to cut you off. Sorry about that. Okay. I'm just going to quickly flip. Oh, okay, that's Cindy. You've spoken. I don't see others turning on their camera or their microphone, so I'm going to proceed. So, all right. Well, again, thank you so much for your attention and your interest. And I see Anne has added. Thank you so much. Okay. Lots of us come to this with wearing lots of hats, and that's life, isn't it? Glad everybody's here, and glad for your interest, and hopefully something for everyone. So we're going to try to cover tonight, try to do some level setting of what guardianship is and why families are often so encouraged or sometimes maybe even pressured to seek guardianship, and why that is that actually the best thing? What do you do if you feel like guardianship is not the best tool for your family, and yet you're feeling like everyone's saying we really need to have that? Because one of the things I'm always super excited to talk to groups about is families get in profession. I mean, there's a lot of myths out there about guardianship. There's a lot of misunderstanding. There's a lot of historical default practices that aren't necessarily relevant anymore. And not everybody has been able to keep up to speed on that and kind of keep repeating the way we've always done things. So these are kind of the reasons we sort of want to frame tonight's talk around understanding the benefits. And actually, I'm going to not spend as much time on the benefits. I want to take that for granted, that there's benefits of guardianship. We know about those kinds of things, the safety and protection and the ability to speak for somebody who has a hard time speaking for themselves. But you'll find that I'm really going to spend a little more time on the potential downsides of guardianship and why, and to be able to then sort of pivot into all the different decision-making options. Starting from a place of, again, as has been the norm for so very long, with people with young people turning 18 who have a disability, it has long been a presumption by professionals, by families themselves, by the friends, by other parents who have kids who've turned 18. There seems to be this assumption or even an insistence that parents must seek guardianship because of the diagnosis as the young person reaches the age of legal majority. Sorts of presumption, recommendations, pressures, requirements. Sometimes it happens with really good intentions from professionals, from special ed professionals, from social workers, from doctors, as they discuss transition times. For some families, we hear it happens as early as childhood, at the time of diagnosis, when your kid turns 18. And I use the term kid lovingly, not pejoratively or not disrespectfully. If that's a term that bothers anyone, please let me know. I want to be sensitive because I know language matters. But often families start getting told at the time of diagnosis or young childhood or young teen years, when they're 18, you're going to have to get guardianship. Be thinking about that. And that sort of hangs over people for a long time. And so for some families, by the time that young person is reaching 18, it's really a solid presumption. It's a given. This is what we're going to do. And I will tell you, it can be really hard as my office hosts the statewide guardianship information line, and I'll talk more about that resource at the end today. But I will tell you, we receive a lot of calls from families who, by the time they get to us to talk about how do we get guardianship, it can be really, really hard to walk back a few steps and explore, is that the best tool? And if it is, great, but is it always the best tool? In one form or another, I suspect what many in this room have heard, what we know, what we have, it's been reported to us, people here, you got to get guardianship. A gentleman walked into our office yesterday. We have to get guardianship when my daughter turns 18 at the end of next year, because the doctors are telling us we won't be able to do anything for her anymore after that. Your kid will get taken advantage of. You won't be able to participate in the special education programming, the individualized education planning. Your kid's not independent, or parents recognize themselves. My kid's not independent. They don't understand all the complexities of waiver services and residential services and vocation services and all those things. And so therefore, in order to have help access services, people are told, or it's implied or presumed, get guardianship at that age of 18. And so many parents even start thinking about it and start feeling very anxious. My kid's going to be 18 in a month and 6 months. I better have it in place the moment they turn 18, or the world will fall apart. All of a sudden, we won't be able to do all the things as we talked about in the thought bubbles in the previous slide. But we want to be thinking a little differently about what happens for people with disabilities as they turn 18. Graduation, college, jobs are all considered rites of passage for people as they reach adulthood. But we've also heard some people refer to guardianship as a rite of passage for young people who have disabilities. But as we're going to talk about today, even though comes from a very well-intended place, and a place of, I think this is what we have to do, guardianship also comes with a significant loss of rights and some unintended consequences for both the student and also their families. This conversation we're going to have tonight is a conversation about independence and decision-making and guardianship and alternatives. This is happening in Minnesota, across Minnesota. This is also happening across the United States, and frankly, internationally as well. I want to emphasize as we talk tonight that in some cases, guardianship is absolutely the best tool. But we ought not be talking about a tool that removes a person's rights and transfers them to a guardian. We should not be talking about a loss of rights as a rite of passage. Guardianship might have been needed in the past. Sometimes we are working with people who are guardians over their kids who are in their 30s, in their 20s. Guardianship might have been needed. The systems might not have been in place to avoid guardianship. It might still be needed now as we go forward, or it might be a really good idea with the knowledge we have now, the changes in the statute. It's not a bad idea to reevaluate if the situation is different enough that maybe the guardianship that was put in place already isn't needed anymore. So these are all the kinds of things I want to be addressing tonight as we go forward. And as we'll talk about, even students who need significant help in their meetings, in their transition planning, in their daily life skills, as we'll be talking about, in and of itself, this lack of independence is not automatically indicative of a need for guardianship. We have countless opportunities to support people to ensure they have access to everything they need, but not necessarily tying it to guardianship. So again, let's do a little bit of level setting about guardianship and conservatorship in Minnesota, just so that we're all on the same page, so that in case there are people who have different knowledge bases or understanding. So guardianship conservatorship is, by definition, a court-appointed relationship of a substitute decision maker on behalf of an individual for whom it's been proven in court that they lack decisional capacity and for whom there's no other way to get their needs met. In Minnesota, because of the stakes of guardianship, the unintended consequences, the transfer of rights from the individual to the guardian, we want to make sure that we are doing it only when there are no other options. And so most often when a young person, and when a person of any age with a disability is open to the idea of help and assistance in decision making or in connecting to services, we really should not be doing voluntary guardianships, because if a person's willing to have that kind of help, that is a great opportunity to explore less restrictive ways to ensure they get their needs and wishes met outside of guardianship. So most often, guardianships in Minnesota are involuntary, and conservatorships as well. When we're talking about guardianship, that is the decision-making authority over the person's body, over where they live, who provides care, where they receive care. A few other slightly confusing pieces. A guardian has authority over a person's personal property. If there's no conservator, a guardian has authority to engage in connecting them to governmental benefits, to signing contracts. But guardians don't manage money in their role of guardian. They might wear another hat, like a representative payee, and manage money as a representative payee. But in the statutory authority, the legal authority granted to a guardian, it's only decisions over personal decisions, the body. And then we have conservatorship, which is, again, the corollary, or the opposite, maybe, the authority over things related to money, property, estate, assets, investments, income, etc. Language is important. We are working really hard across all our systems to get away from ableist language, stigmatizing language. We try to embrace person-first language. And so we no longer call people who have a guardian a ward. They used to be called that up until 2020, but they're not wards, they're people. Or if we want to be technical and legal, they are a person subject to guardianship or a person subject to conservatorship. Again, I really want to emphasize guardianship is an excellent tool when it's necessary. Sometimes it's the only way to protect a person who is living with vulnerabilities, safety concerns, lack of access to basic care, because of a plethora of situations, of issues in their situation. They will otherwise be wholly unable to be safe and well. Then we might need guardianship because of their unique situation. Or sometimes guardianship or conservatorship is the only way to meet a person's goals. That person who wants to live in their own independent living skills apartment, but they lack all ability, any ability. They sabotage, intentionally or not, any efforts to help them be successful at that. And so maybe we need a guardian, and maybe we need a representative payee that can consent to the services, even if the person tries to decline help, or the person doesn't use part of their money to pay the spend down. So sometimes we need that court intervention to make sure that we're getting that person's goals met. But for the reasons I've mentioned and the reasons we're going to talk about more in a little bit, we do want to make sure we're using it only in frankly extreme circumstances. We want to think about it as a failure of all other efforts to use when we're going to use guardianship. And times are different than they ever have before. We are no longer defaulting to guardianship as sort of the thing for people with disabilities, whether it's younger people turning 18 across the lifespan, or for older adults approaching who have neurocognitive disorders like dementia. It's not the default. It's still there. It's still available. It's not going away. It's good when it's necessary, but we want to use it as a last resort. And our statute reflects this. Our guardianship statute has been around in Minnesota for eons. I don't know how long specifically, but we did some pretty major updates to the guardianship law in 2020 to reflect the changing times, to reflect that we look differently at how we view people with disabilities and how we determine whether to remove rights and grant it to the guardian in the name of protection. So our laws now are pretty specific, and I want to give you a little bit of specific information so that if you feel you do need to seek guardianship over a family member or a friend or somebody you care about, you have to make sure that you will meet the statutory criteria. You have the petitioner, that's the person who fills out the petition, signs it. Maybe you do it with an attorney, maybe you do it on your own. The petitioner is the one who gives the primary testimony in the court hearing about the need. The petitioner has to be able to prove in the court hearing with clear and convincing evidence. That's a pretty high bar. that the person meets the legal criteria of being an incapacitated person, meaning, according to statute, that they have some kind of a diagnosis, some kind of condition, which causes them, it's the condition itself that causes them to lack understanding or ability to make their personal decisions, and that they have unmet needs for personal needs, food, clothing, shelter, medical care, safety, supervision. Even if we add in technological assistance, even if we add in supported decision making. So we have to prove three things, and the third one is on the next slide. We have to prove the diagnosis, that because of the diagnosis, they're unable to get their needs met, even when we provide support. And then the third piece, and this is really, really critical, we have to prove with clear and convincing evidence that those needs can't be met in any other way than the guardianship. And the statute in the language in purple here is new language as of 2020. The statute gives us examples of less restrictive alternatives, and it is not intended to be a conclusive list, an all-inclusive list. It's giving us examples. So if we can support a person, if we've got safety concerns, they don't take their medicines, and they live in a place where there's no one there to remind them, can we bring technological assistance like a medication reminder? Can we use tech assistance through internet-based services with banking to get their bills paid so they can continue receiving the services? Can we support them in making the decision? Can we connect them, and will they work with us to get community services or residential services? Can they complete a healthcare directive? I'll talk more about these in a little while, but just want to make sure you understand that it is a very high bar. It is no longer just the person has an intellectual disability, they're 18, we need to get this level of protection. There's a lot that goes into it, and I'll tell you more in a minute. I also want you to have the language. Again, you've got these slides, so I'm not going to spend a lot of time on conservatorship. The language is parallel, but for a lot of the people we're working with, young people with a disability that are turning 18, they haven't accumulated wealth in many cases, and so they don't really have funds that need to be managed, which is what conservatorship is. We have to prove inability to manage their money, and that either their money will be wasted, people keep taking advantage of them if we don't get control of the money, or we need to access their money to pay for their care, support, and services. And similar to the guardianship, there's no less restrictive ways, such as banking assistance, supported decision-making, representative payee trusts, appointing a power of attorney, etc. So that's the corollary for conservatorship. A lot of the folks we're working with would not need conservatorship, even if they can't manage their money. But if their only money is SSI, for example, then a representative payee is sufficient. There's that, there it is right there listed in the criteria as an example of a less restrictive alternative. So if a representative payee can be appointed by Social Security to manage the SSI, don't go for conservatorship. Trust me, don't go for it. It's a whole lot of extra hassle, and you don't need it. Now, this is a new part too, another nuance to just to hit home what I've been talking about. You can't just say, and there's no alternatives, we got to get guardianship. You actually have to list in the petition what less restrictive alternatives have been tried. How long did you try them? Why don't they work? And then be prepared in the court hearing to also list and describe what's been tried, how long, why didn't it work? Really a high bar now. And so sometimes when people say, but I know in the end, I just want to go straight for guardianship because my kid has significant disabilities. Well, you're going to have to try alternatives, or really be prepared to explain to the court why you didn't try the alternatives. Another new piece I want to make sure people know as of 2020 is that for people, now if a guardianship was already established prior to the law going into place in August of 2020, this doesn't apply. Any petitions for new petitions for guardianship that were filed or granted after August 1 of 2020 for people who are under 30 years old. So it's a fairly small slice in anybody going forward from now. If the person is under 30, regardless of the level of their disability, the guardianship is automatically going to be terminated. It's just going to expire after 72 months, or a shorter period of time if the court says less than 72 months. It expires automatically. However, If it is felt that the person still definitely needs a guardianship and and the petitioner, the family, can continue to prove the need for guardianship and the lack of alternatives, petition again for another 72 months. And then at the point where a guardianship is appointed when the person is 30 or 29, almost 30, then it's going to be a permanent guardianship unless the court order limits it. That's my tutorial on guardianship, and I went really fast. So, and then I'm going to start talking about some of the alternatives. Actually, I'm going to keep talking about guardianship a little bit more, about some of the downsides of it. But I do want to ask if people have questions about the process. We can't get into the nitty-gritty,
there is a question in the chat.
Okay.
Let's see. Jennifer is asking, what about the conversation with the child that seems they do what their parents say?
So Jennifer, do you want to say a little more? Yeah, thanks.
Yeah, so I do pre-eds primarily.
Can you tell me what that stands for?
I try to get the students into VR.
Okay.
And get a social worker. Primarily, I'll just say this indication, that's why I'm asking the question. I have a student, she's a super senior. Are you guys familiar with what that is?
I'm not.
So if you're a super senior, you can actually like go through high school, but you have until the age of 21. Now they change it to 22, that you can actually go to high school and they will put a transition place and program for you.
Okay.
Whether they come to my PAYS lab or I get them a work experience or something like that.
Mm-hmm.
I have this particular student and she's a super senior. She is going to stop doing school after the end of the Thanksgiving break. According to VR case, she can't be in a VR case because she already has a job. She's in our PAYS program. Her mom is really reluctant to meet with me, trying to get her to do other things to move on.
Mm-hmm.
And I'm just curious what your consultation would be about how I should move on with her as a student.
So she does not have a guard. How old is she?
She is 19. Her
Okay.
mom is her guardian.
Her mom's went to court, because that's an important piece. Did they go to court or do they kind of just call themselves? So they went to court.
She is her mom is her legal guardian,
Okay.
and this particular student of mine lives independently in the basement of her mother's home.
Okay.
She does have employment, community
Mm-hmm.
integrated employment,
Mm-hmm.
a couple of days a week. I don't know how to move on with that case.
Okay. Okay. Because she wants to do one thing and the guardian is maybe, we don't know what the guardian exactly wants, but the guardian's not being cooperative or communicative with you.
Correct.
Yeah.
Correct.
So I did include, and tonight, unless we have time at the end, we're not going to spend a ton of time about when guardianship's already in place, because that's another conversation. But I did give you the list of the Bill of Rights, statutorily enshrined Bill of Rights, which specifically says, I can't remember which number it is, specifically says that people, even people with guardians, have the right to vocational services, employment services. I don't think I put it in the slides, but Minnesota does have a guardian complaint investigator.
Never do that. My question is, because she's in pre-eds right now,
mm-hmm.
and she's going to graduate after the Thanksgiving break, she will lose her pre-eds benefits because she will be a graduate of a high school. But she's not eligible for VR benefits either because she's already employed. Is there a bridge between the two of those?
That is a great question that is outside of my area of expertise, because I'm not an expert on those services. I really know more about guardianship and rights of people subject to guardianship and so forth. So, but maybe someone else in this room has more knowledge about and more ideas and creativity. I'm sure you've already done this, but the more that you can talk with the mom, the guardian, about, this is the consequences of the decision. And by the way, your daughter has the right So is there someone else in the family that can, or someone else in the community that the mom will listen to and talk with?
And I've
Yeah.
talked to her special education teacher. I can't get her mom to show up for a meeting, but I just
Yeah.
didn't know if any of you guys had any advice or anything that would help me breach the
Bridge
pre-eds
that.
to the
Yeah.
greater
I would, this is probably a room full of experts in these areas. So if
And
people
that's
do
why
have
I'm here today,
ideas,
actually,
yeah,
about this
yeah.
particular student,
Oh,
also about
okay.
everything else. Yeah, so I didn't know if anyone had anything to say or.
Yeah, if people want to drop any ideas you have for Jenny in the chat, that would be really, really appreciated. And I'm going to kind of keep moving if that's all right. Respectfully, I'm sorry.
No, I
Thank you.
apologize.
No,
Yeah.
no, I'm glad you asked the question. That is a big issue. And I, when I started going down the road a little bit about how to talk to the mom and try different approaches, when I get into the part about talking about supported decision making and how do we talk with people to help them understand and make the best choice as professionals, when we're working with guardians or working with family members or working with other professionals, we can also utilize principles of supported decision making with them too, helping them understand the consequences of the decision the guardian is making on behalf of the person subject to guardianship. So the changes in the law, the idea of making it, some people would use the phrase making it harder to get guardians, upping the requirement to really try genuinely, authentically try less restrictive alternatives before petitioning. Really, all of this is about looking at people with disabilities differently, looking at services differently than we have historically, more about looking at people like we look at all people as human beings, people first, not overemphasizing vulnerability, but looking at people, people who have a right to live the lives they want to live, albeit needing some extra support to make sure care and safety and well-being is met too. But we are again, very different approaches for some of us who've been doing this a long time. Not so different for some of us who are coming up in the era of person-centered and person-first, person-centered interventions. This is all you've ever known for younger people in their careers. This isn't as hard of a switch, but it can be harder for some people who have been around for a while. It has been only in recent years where we've really started to talk out loud about the fact that guardianship comes, for all its good intentions and all its protective approaches, can really come with unintended consequences. It can be a traumatic process, even just to get a guardian appointed, because the focus of the process is on the person's needs, deficits, challenges. This isn't about recognizing a person's resilience factors and support factors. It's about all of the detrimental aspects of their condition. So it can feel very traumatic to have a spotlight shining on the person's disabilities. It can be hard for people. It's less hard. It's less intimidating now that a lot of court hearings are still on Zoom. But physically going to court, going through security, talking about lawyers, being in front of a judge. Some people feel that they're criminals or in a criminal system, not understanding that. Families often don't understand that just the process of getting appointed as guardian, if the individual or another family member opposes it, it turns it into an adversarial court hearing. And family, again, who wants to get the guardianship appointed has to push really hard right in front of their kid about all their kids' deficits and problems. That can be painful for the family. Families have to, once they're appointed as guardian, they have ongoing reporting responsibilities to the court, which aren't super onerous, but they're another thing you have to do. And that can feel burdensome to families. So it can be more stressful than people think about. For the individual with a guardian, just that sense of, I'm not my own person. Think about even the phrasing we use. We say so-and-so is their own guardian, and so-and-so has a guardian. And when they're talking to providers, when they're talking in the various systems they're interacting with, whether it's school or in the group home or in the community. I don't know if you could do that. We have to ask your guardian first. And guardianship from the time a person reaches age of majority can really lead to really learned helplessness and this culture of compliance, of people like me better when I go along with them. And I think I feel like you were starting to say that a little bit too, Jenny, before, of somebody who just kind of, well, that's what's best. That's what my guardian wants. And people who have that learned helplessness and who find themselves in a situation of being more compliant because then people don't get mad at them, really also lose that sense of agency. And a lot of studies are very alarming that say, that indicate that people subject to guardianship might have even a higher risk of being abused than people with disabilities who don't have guardians. Sometimes guardians, for all the good intentions, can be so overly protective. Sometimes I call it wrapping someone up in the bubble wrap of safety. I'm so safe, I can't do anything, and I'm miserable, but nothing bad will ever happen to me because of my well-intended but overly protective guardian, or the systems taking care of me that my guardian is interacting with. Sometimes we think that because we have a guardian, now a person's going to be safe and we don't have to worry about them. When the truth is, unless we follow a person around moment to moment throughout every day, or unless we have a person lived in a locked facility somewhere, they're still going to be interacting out in the world and still have opportunity to get engaged in become engaged in unsafe activities. But we think they're not because we've told them as guardian, or we've told their providers, they can't go on the internet, they can't smoke, they can't date. And what's really happening in some cases, we think they're safe because we think we've set up those rules, and the person sneaks around and does it anyway without any of us knowing it, which is even more dangerous. Sometimes once we just by having a guardian, and then a doctor says, well, this person is overweight, we need to have them on a low calorie diet, a low salt diet, they need to take medicines for high blood pressure, cholesterol, you can't have the food. And guardians like, okay, the doctor said that, I'm going to consent to it. And then all of it, we all wrap around, you can't have those things, and you can't have the food you want, you can't have the snack, and then what does that do? The person feels restricted, and the person might then binge on other things when they can sneak and get to it. People are miserable. If we think about all of us who don't have disabilities, if we did everything that is exactly 100% prescribed by the medical system for our own health and well-being, we could be pretty miserable, couldn't we? And again, the recognition that a guardianship is a transfer of rights. I've already talked about promoting a false sense of security. Sometimes guardianship leads to less emphasis on growth and development because we don't have to worry, we have a guardian. And so the person never learns how to make decisions they never learn good decision making, because frankly, how did we all learn good decision making? We made some mistakes and we learned from our mistakes, right? People with disabilities who are so protected from themselves never even get to make a mistake, don't get the dignity of choice and the dignity of risk, and never learn how to make good decisions. So they kind of remain a child forever, and it becomes self-perpetuating. My person can't make decisions and they'll never be able to, but also they've never been in an opportunity to learn to make decisions. So we can never get out of guardianship once in, because it's just a perpetuating cycle. Again, not all guardianships, not all situations, but that can happen. A couple other things with practical realities of guardianship and I've alluded to this earlier, a guardian has an authority to consent to care and services and diets and medical compliance and so forth. But just having that authority to consent to it doesn't enable us to get the person to cooperate. We can't force a person to be compliant. And if you don't believe me, think about being very careful. I'm not equating adults with disabilities to children, but think about if you have had a 4-year-old, a 2-year-old, a teenager, you have the legal authority over them, but can you get them to stop doing the thing you want them to do? Probably not. You can tell them they can't do it, but the behavior is still going to happen. And so really our approach with people isn't wielding our piece of paper that gives us the authority. Our approach is working with them, finding ways to navigate through what they want to get to what we want them to do or not do for their own health and well-being. So it's not a power of forcing a person's behaviors to do something or not do something. I referenced already the Bill of Rights. Even though people lose a lot of rights with guardianship, they also retain a lot of rights. One of the primary rights with regard to young people who want to live lives like everybody else lives, like maybe dating, maybe sex, maybe intimacy. Sometimes we think about getting guardianship to protect people from getting hurt or taken advantage of, for sure, but even to try to protect people from getting emotionally hurt or physically hurt. But the Guardianship Bill of Rights says people retain the right to continued interactions with people of their choosing in the forms they choose, unless a guardian has reason to believe it will pose significant physical, psychological, or financial harm. Then they can restrict interactions, but even then can restrict interactions only to the degree of addressing that likelihood of significant harm. So we can't just unilaterally use guardianship to protect a person from themselves. It's just not going to work. We also have to be thinking about, particularly with these guardianships that terminate, what's going to happen when the guardianship ends? What are we doing in the meantime to help the person grow and learn skills? Or maybe it's a guardianship that's going to go on for decades and decades. What's going to happen if you, the parent, when you age and you are unable to care for your young, now middle-aged adult, and trying to convince other family members to step into the role of guardian can be a lot more difficult than trying to convince other family members to step into the role of, can you be there and help support this person, versus taking on all the legalities of guardianship. So lots and lots of things to think about, lots of things we historically haven't considered very much when we thought about protectively and perhaps overly using guardianship for people. But the good news is guardianship is available when it's necessary. We have some protections around guardianship, and also we have a plethora of ways and approaches. And our systems are also changing to support the idea that we can meet a person's needs, their safety, vulnerability. We can address safety and vulnerability and inability to connect with their own care and services while preserving their rights, while keeping the government or the court out of our lives, of the family, which, trust me, is huge when we can accommodate all those goals without having to go to court. And again, that might be in the realm of supported decision making. That might be in the realm of healthcare directives. I'm going to talk a little bit more about some of those. Sometimes people think about a healthcare directive, or sometimes people call it a living will, or they call it a healthcare power of attorney or a durable power of attorney for healthcare. In Minnesota, all of those terms are sort of folded into the term of healthcare directive. And a lot of times people think about healthcare directives just for older people or people at the end of life, people with cancer facing the end of their lives, or a serious illness. And when in fact, anybody who's 18 or older ought to have a healthcare directive. And even people with, significant intellectual or psychiatric or neurocognitive disorders, if they can reliably indicate who they want to make medical decisions for them, that's sufficient capacity to complete a healthcare directive without then having to go get guardianship. We can help people get situations put in place so that their money is protected and their money is used appropriately, that they have enough pocket money, but that their spend downs are taken care of so they don't lose their waiver services, for example. Somebody else, it doesn't have to be a guardian, it can be a family member, it can be a social worker, someone else can be authorized to represent the person in completion of medical assistance and waiver applications. Somebody can be a representative payee through Social Security. So people can sign releases of information that, remember the thought bubbles, the doctor won't talk to me, I won't be able to be involved in the special ed planning because my person is going to turn 18 and they're an adult. Well, are they willing to have you still stay involved? And will they can they have basic understanding that signing this piece of paper means mom or dad or brother, whomever, has authority to talk to my special ed professionals, my social worker, my advocate, even if I'm not in the room. If they can understand it, we explain it in ways they can understand. A release of information can go a very long way to addressing all the things that families are told you can't do, and that's why you need guardianship. But I want people to know, when we're trying to advocate for options other than guardianship, sometimes people say to me, I can't possibly not have guardianship because we can't just leave them to their own devices. Well, nobody's saying leave them to their own devices. It's not guardianship or nothing. Guardianship, or they're their own person and we just go, gee, I hope everything turns out all right. It's a balance. It's finding the balance. It's building in scaffolding, what I call scaffolding of support, safety nets. It's building relationships with the individual, maintaining relationships, finding ways to reduce the risk, turning to our community, building community around the person. All the things we can do to help address those safety and vulnerability issues without automatically having to go to court to obtain guardianship. And that's what supported decision making is. It's this newer, for a lot of us, it's a new term to describe exactly how we've been interacting with the people we serve or our family members our whole lives, our whole professions, but it's a newer term. What is supported decision making? Kind of like it sounds. And we have the legal definition in our guardianship law. Remember, in the guardianship law, no guardianship if there's a less restrictive alternative, including supported decision making. So what is it? In Minnesota, the legal definition is quite simply help from other people, another person, many people, assistance from one or more persons of an individual's choosing in understanding the nature and consequences of potential personal and financial decisions, to enable the person to make the decisions, and if the person wants, to communicate the decisions once made. I am seeing chats that I should just quickly take a peek at. We're still answering Jenny's question. Okay. So just keep chatting there. Any other questions for me as we kind of pivot towards supported decision making? Okay. All right, so we've got a statutory definition. We've got a requirement by the statute that we try supported decision making and other alternatives before we go to court. And we could still go to court later if we need to, but we have to try. And how we try is by helping support the people. What is supported decision making? It's quite simply how we all make decisions. It's the recognition and acknowledgement that if everyone who needed help making decisions needed a guardian, we would all need a guardian, because at different points in our lives, depending on the scope of the decision, depending on how we're feeling at a given moment in time, we all turn to trusted others to help us better understand our situation when we're struggling, we don't know what to do. And this principle of nobody is wholly independent, and just because you're not independent doesn't mean you're incapacitated, doesn't mean you have to have a guardian. And we also know, study after study have shown, and we know anecdotally, people who feel that sense of, we call it agency or self-determination. I'm the captain of my ship. I may need lots and lots of help, but I ultimately get to make the decision, have better outcomes, more likely to be employed, live in community settings, better mental well-being, more likely and able to recognize and resist abuse. So again and again, we know that people who are more empowered, quite simply, are going to be making better decisions and are going to be more open to others helping them to make decisions.
The reason that I ask you is because I do have some clients that have signed waivers, or that say that someone else is in charge of them.
Mm-hmm.
In the end, they still get to make the process. Like, for instance, I'll just give you one instance. this person was going through cancer. They recommended that someone else was going to be in charge of them. They got rid of cancer. And so the other person was still in charge of them. How would that relate to what they signed?
Can you
As
tell
far
me
as that
more
form.
what you mean when you say someone else was in charge of them?
So what I mean was they signed themselves over, like X person said, you're in charge of my cancer treatment.
Okay.
They were about to die.
Okay.
They actually woke up and then they said, I don't want to do that anymore. But X person was in charge of their actual cancer treatment.
Well, if they didn't go to court to become guardian,
They were the court legal guardian.
okay, so they did go to court. So now that person definitely has an opportunity. It is allowed in statute to petition the court to terminate the guardianship.
So that's how you would do it. And
Yeah.
how would you go about doing that then?
Well, I would encourage, I'm gonna not spend I would
We
encourage
can
case by
talk
case.
later together.
Yeah, contact our guardianship information line to go through the specific case, but other people in the room might have a similar question. So, generally speaking, the petition to modify or terminate a guardianship is the same process that they used to set up the guardianship. So the individual has the right, according to statute, and it's in the Bill of Rights as well, the person has the right to either contact the court and ask for an attorney. Given on any given court may or may not do that, but they have the right to. There are forms, and I have a resource slide for you. There are forms on the Minnesota Judicial Branch website where somebody such as yourself could help download the forms and help the person fill them out and file and get it filed with the court in the county where the guardianship was originally established. And hopefully what the court would then do is get a hearing scheduled, and then there would be a hearing, which is sort of in reverse of setting up the guardianship. Now the hearing is, this person doesn't need a guardian and here's why. And hopefully then the guardianship would be terminated.
Right. And if they lived through the situation, they would be in guardianship of themselves. Right.
Then they're just like you and I. I kind of try to not use the phrase they're their own guardian, because you and I don't say that about ourselves. Sure. They're their own decision maker. Yeah, but that's exactly right. You got it.
Okay.
Yep. So another tool I like to help explain, and we're trying to cover a lot tonight in an hour and a half.
I'm gonna stop asking you questions.
No, you don't have to. That wasn't my point. Jenny. Thank you. I'm glad you're asking questions and I'm glad you're engaged. Thank you. Don't censor yourself. But what I was gonna say is I'm giving everybody sort of a high overview of supported decision making. And I also included in the handouts this little tool. This is a one-pager and it's kind of hard to read on the slide, but it does a nice job. It's developed by the National Resource Center on Supported Decision Making. And it does a nice job. Like, I think, Jenny, you were the one who said you wanted to bring this information back to your coworkers. If you're anything like me, you hear a new concept and you love it and excited, and then you go to people and you're like, I don't think I can explain this. So this tool, I think, is really helpful too. It sort of goes through what I've been talking about with the bubbles. If you follow it around, what's supported decision making, what happens now, what this is all about is thinking differently about how we view people with disabilities as human beings, not as vulnerable adults, human beings who may have some disabilities and some vulnerabilities, and how it's our job as systems, as professions, and it's a moral duty as communities to support people. It's part of the Americans with Disabilities Act, quite frankly. We think about ADA as all the accommodations for physical disabilities, but really the ADA is really also intended to be about reasonable accommodations for people with cognitive, psychiatric, intellectual disabilities. And so whatever we can do, we have responsibility as communities and systems to support people in their areas of challenge without taking away their basic civil rights. So this is just a tool for you to have if it's useful. I like to hang it up in my office and refer to it. I like to share it with people who are a little skeptical about it and hear someone else's words, I think, and I think it's a pretty persuasive document. So that's just a tool available to people. Again, for people for whom this sounds a little alien and unusual, I really call out, you might already be using a supported decision making. And some examples from the brainstorming guide, which is available in the slides. I give you some resource slides at the end from the National Resource Center. This brainstorming guide helps, I like using it as an educational tool as well as a workbook for families as they think about, well, how might we help people? My kid, my young adult, my family member, this is too complex to understand complex medical decisions, that complex care, all that goes along with that complex cancer diagnosis. But if we're going along with the person to medical appointments and we're helping take notes and then we explain it to them later in language that's more accessible than what the doctor used, we're helping people explore what's the best healthcare plan. We're using the release of information so we can review the medical record, or we can talk to the doctor or the social worker or the nurse in the doctor's office, and then we're helping the person understand. So then the person says, oh, well, now that you explain it to me that way, sure, I'll take that vaccination. Sure, I will, whatever the case may be, once we help them understand it. That's an example of supported decision making. It doesn't matter that a person can't figure out where they need to live when they need a supportive living environment. I don't know all the options. When Jenny asked that question earlier about bridging between the two, education and voc rehab and so forth, are they bridging? I don't know, but someone else might be able to explain it to me or to the person we're working with or to the guardian. Same thing with figuring out where to live. Anytime somebody is going along with the person to tour different places, making lists, pros and cons about different places to live, including continuing to live at home in a room in the basement versus their own apartment. Whatever we're doing to help the person and the person is involved, and they're ultimately the decision maker. Supported decision making is about making decisions with the person, not for the person. More examples in managing money. We can do joint bank accounts. We can make a budget together. So this person, they'll get taken advantage of. They don't know how to count change. Well, first of all, a lot of people don't know how to count change either. The cash register tells them we don't use change anymore. So it doesn't really matter if they can't count change when they never have to count change, right? But can we help them learn? Can we teach them if they're going to be using change, the difference between a penny and a quarter or a $50? Or they have somebody in place who manages the money, but sits down with them every month and said, okay, here's your bills. Here's the money we have available to pay, and then here's the leftover. And with the leftover, you can spend it all today on the Pokemon cards. Or would you like me to help you? Would you like me to hold on to it so we can accumulate it for a few months so you can take that trip to the amusement park that you've been telling me you want to do, but you didn't have enough money. Anytime we're helping the person understand their situation. So these kinds of tools are examples that people might already be using or would be willing to try instead of going straight to the guardianship approach. So as we think about what should we do, what's next, how do I know, should I use supported decision making, should I use guardianship? I would start with the person you're thinking about. What are their deficits? We'll use the deficit language. What are their areas of support? They need help with money management. They need help with healthcare decisions. They need help applying for a waiver so they can get services, so they can continue living in the place of their choice. They need support in special ed and making those decisions at that transition age. Life skills, dating, safety. So just really start thinking about, as soon as we start identifying the areas, instead of this global, they've got an intellectual disability, so they need a guardian. What are the specific areas that they need help in, that they cannot currently do by themselves? And start thinking about it way before 17, way before they're almost 18. Don't spring it on. My colleague Kathleen was just at a webinar last night for parents of kids with intellectual disabilities, and there was a young person with a disability who was part of the panel, and they were, or I think they were attending, and it doesn't matter who they were. Anyway, they were saying, don't spring this all on me at 17. I can't do all this. It's too overwhelming. Why weren't we working on my areas of need for the years approaching? We all know I'm going to be 18. Let's start working on these things years before 17. But once we identify what those areas of deficit are, then we can start thinking about the corollary tool. Money management, maybe they need a representative payee. Money management, maybe they need a co-signer on their bank account, or someone with authority to use the internet to take a peek to do online banking. Maybe not manage the money for them. They've got ability, but not confidence, or they've got ability, but sometimes they get talked into things. Maybe somebody can just take advantage of the online banking and log into their bank account and just make sure that wacky things aren't happening, right? For people who do have more assets, work with an attorney to set up a trust so a trustee manages and protects the money. Maybe set up where they sign and appoint someone as their attorney in fact, which is the name of the agent in a power of attorney to manage the finances. I mentioned earlier, even a person with pretty significant disability, if they know that they want X person or persons to make their healthcare decisions for them, or to talk to the doctor because that's too scary and intimidating, appoint a healthcare agent. We don't need a guardian. We just need somebody with the authority. Maybe just sign a release of information. Maybe we just need somebody to get them on the waiver services and then help maintain the waiver services for all the recertifications. Just because a person can't manage and navigate MA by themselves doesn't mean they need a guardian, because again, that's a pretty complicated process for all of us. Going through person-centered planning, finding a PCP facilitator to help think about life goals, where the person wants to be and how to get there, and what's going to be needed to get there outside of guardianship, building in the supports that are needed for the particular areas. I mentioned release of information forms. Using, when we think about, but they're going to get taken advantage of and they're going to get hurt in a dating relationship. Who doesn't get hurt in a dating relationship? But they're going to get catfish. They're going to get, somebody's going to scam them with, well, let's teach healthy online. Let's teach online literacy. Let's teach healthy relationships and healthy boundaries so people can make better decisions, or at least, if we're not setting it up as I'm going to, in essence, punish you every time you get into a bad situation, and we're going to do guardianship, if people, they're not going to come to us. If we want to have those trusting, open communication relationships, so they do come to us when they get in trouble, and then we're dealing with those safety concerns as they come up, because we have that open communication in our relationship. Sometimes it's a matter of just harm reduction. Sometimes we want to reframe. It's not reasonable to think nobody's ever going to be hurt in any way ever. If there is, like I said, the bubble wrap of safety that leads to misery, or locked in a protective unit, misery, we want to maybe instead be thinking about as safe as necessary rather than as safe as possible. Maybe we want to use technology. They might get lost. We're worried they might take off. Maybe they have a smartphone that we have, the GPS on. Maybe they're learning transportation. Maybe they're using Google Maps so they don't get lost, so they can find their way home. All the things. Countless ways. It all just keeps coming back to what the person's individual situation, their support system, and how creative can we be in addressing their needs without having to seek guardianship. But for some people, might need guardianship. For people who have a family member or a client or person they're working with, there's just no other way to get the person's needs met, despite all the creativity that was attempted or ruled out. If we can feel somewhat confident that the benefits of guardianship will in fact outweigh the harms or the potential harms of guardianship, then maybe we did need to go for it. When we don't have to start a year and a half early. We want to do it start 4 to, if you're really really uncomfortable, 6 months before the 18th birthday, you can start working on getting ducks in a row for the guardianship petitioning process. I highly recommend people work with attorneys because it's a pretty burdensome process, and the person subject to guardianship, there will be a court visitor who comes to visit them and serve the petition on them. So they're going to read, it's going to get read to them what you write in the petition about all their deficits. They're also going to have an attorney appointed to represent them. And the attorney, every attorney is different. Attorneys may approach it different ways, but the attorney is supposed to approach it in terms of a zealous advocate representing what the person wants, not necessarily what you think is in their best interest, but what the person wants. And so, and if the person, in the way the attorney phrases it, and the person says, no way, I don't want a guard. I love my mom and dad. I don't care if they help me, but I don't want a guardian. I don't want guardianship. That attorney then is supposed to fight your petition. And there you are by yourself without an attorney fighting against your kid's court-appointed attorney. So I recommend an attorney. But I also recognize it's not always easy to find an attorney. The statute says that the court, if the individual needing a guardian doesn't have money to pay for the guardianship costs, that the cost, meaning court filing fees, attorney fees, gets paid out of, if the individual doesn't have the money themselves, the person needing a guardian doesn't have money themselves, you shouldn't have to pay as a family member. It comes out of the court or the social service budget. But different counties do it differently. And so it can be, I will admit, it can be hard to find an attorney who's willing to take what the court will pay them as their payment in full. Or they might be willing to do that, but they might ask you for a retainer. Or some attorneys might just say, sure, I'll represent you, but it's going to cost, my estimate of how much it's going to cost you is whatever, $3,000, $4,000, $6,000, $7,000. So I know that money is a barrier. It shouldn't be according to statute, but it may be. A lot of families find they can navigate just fine themselves once they learn where the forms are and what forms to do. And there are some there's an entire set of forms that people need to proceed with guardianship petitions or terminations or modifications are all on the court website. There are there's a help desk that will not advise how to or what to put in the forms, but they're supposed to be able to say, yep, here's the forms you need, etc. So there are resources. Families do it themselves without attorneys. I often say, if you can find an attorney, don't use an attorney. And I'm going to tell you how to find those forms because I've got some resources there. And then I'm going to give you lots more resources. I do want to pause. More questions that I should specifically address before I kind of keep working through?
I have a question.
Okay.
So with you're talking about meeting a person's needs and being able to show that you've tried to do them. What if what their needs are not being met by their waivered services to meet what that person wants? Like, for example, my daughter wants to live independently in her own apartment or house or whatever. And I think with the proper supports, she would be able to do that. However, from what I'm told, our budget is for her waivered services isn't going to change very much when she turns 18. And her budget wouldn't allow for the amount of staff that she would need to complete her needs.
Mm-hmm. Mm-hmm. That, so I will say, because I come with my guardianship lens, my guardianship question lens, I will say, being her guardian, being somebody's guardian does not solve resource issue problems. So you can be just as firm of an advocate on her behalf when she's 18 as you are now, without having to go become guardian. You use the release of information and those kinds of things. I would say, I have heard in webinars I've been in that there are funding streams coming down the pike to adjust waiver payments. I would say, you know who I would say to contact is the Disability Hub, to talk through the different resources. The Ombudsman for Developmental Disability and mental health and developmental disability ombudsman. If you feel that you are not, as a family, or that your daughter is not being allocated the resources that they would be entitled to, an ombudsman is a good approach, or a supervisor, or the Disability Hub. Yep. But guardianship is not going to solve resource problems. Yep.
I mean, I get that having guardianship wouldn't change the fact that she wouldn't have the money for staff. As it is, I do most of her PCA because I'm cheaper than the $44 an hour that places charge. However, like, that meant ending my career,
right,
so that I could get her to those appointments and those kind of things.
Yeah.
So but I don't know, I guess I haven't been able to find out, like, if that can continue without me being her guardian.
Yes, absolutely. It should be able to, absolutely. Particularly, I mean, it sounds like your daughter can consent to you being involved, give you permission to talk to people, apply for things with her on her behalf. Absolutely, that all can continue. In terms of how do her waiver services change when between child as a 17-year-old to being an 18-year-old, that is, again, beyond my area of expertise, but you don't need guardianship to access those for her. And thank you for your work. And let's all acknowledge what you know oh so well and have just demonstrated, that the state of Minnesota and most other states in the nation are balancing budgets on the backs of families. Absolutely.
Yeah.
I guess it's a blessing that we can. When I was a baby social worker, I started my career in Wisconsin, and I worked for what we called long-term care support or something. And we had what is now waiver programs. And back then we couldn't pay families, because the expectation back then is family's family, and we're not using governmental dollars to pay family to do what families should do. Well, how fair is that? So at least we've evolved a bit.
Yes, I moved here from Arizona. So this type of thing would not be available there. So I do count my blessings and the fact that this is available. It just is, it just kind of stinks that taxpayers are paying now for me to be on assistance, because
right,
the $15.25 an hour is not enough to support you know, a family. So, and I just didn't want to I was hoping that when she turned 18, that parental expectation wouldn't be there, so that I would be able to go back to work. And that was what I was in my head thinking, not that I had any proof of it. I just was like, oh, well, when she's 18, I'll be able to go back to work and do these things.
Yeah. And if anybody in the room does know the answer to that, in general, and we're speaking gross generalities, if adults in the waiver services, if the capitated amounts are higher, drop that in. That would be good to know. I really do call, and it's on a slide coming up, but I really do encourage the Disability Hub If you haven't already contacted them, they're experts in navigating those pieces as well. And the ombudsman, if you feel like you're not getting the resources. So I like to share resources. I'm not going to show this video, but speaking of the Disability Hub, they have produced, our office has produced a few whiteboard videos as well, but I call people's attention if you could just do a copy paste or enter the characters in YouTube or go to the Disability Hub and navigate through a pretty good short video on what we've been talking about on supported decision making as an alternative to guardianship. I've mentioned the brainstorming guide. This, and again, these are live links. If you got the handouts emailed to you, you should be able to click on it, but I also gave the resource at some slides at the end. This supported decision-making brainstorming guide, I've already introduced it to you a little bit. This is a tool aimed at families, and just like it says here from the excerpts that I put on the slide, it can help families brainstorm ways that they're already using supported decision-making, and it can prompt you to think about different ways you hadn't thought of with some of the prompts. It's a I don't remember, maybe 6-page workbook that goes through helping people in those areas I showed you: healthcare decision-making, life skills, money management, place to live. Just kind of walks you through, what are we doing now? What could we be doing more of? And it also is really helpful then once you've worked through that, if you are getting pressure from your special ed professional, no one in this room, if you are getting pressure from the doctor, from social services, you have to get guardianship, this brainstorming guide that you have worked through and filled out, you can show it to them that you have thoughtfully navigated through the various areas of decisional needs and work together. And this is why you're not going for guardianship, because you've solved these, you've addressed these things and put plans in place. Another tool I like a lot, this one talks more in first person language to the individual with the disability, how to make a supported decision-making agreement, published by the ACLU. And I've just taken a couple screenshots just to show you the great document, and I encourage people to grab it too. And this is something that the young person would work on, and you could all work on it together as a family. But you can see from the screenshot of the table of contents, what is supported decision making? Help me think about choices. You can see it's pretty plain language. This is an activity in chapter 2, thinking about choices you've made, what went well about it, who helped you, who didn't help you, what didn't go well, just to be thinking through what's important and values and choices. And then a chapter I really like in this document, again with infographics, just giving examples of the ways we already probably are doing it, supporting people anytime we help people better understand a decision they face by bringing it into plain language, using pictures, having someone help research different options. Somebody learning how to use public transportation so they can get from where they want to live to their job, or their job back to their parents and living with their parents. Do trials. It just does a nice job of prompting, especially if you're like me and a little bit more literal or black and white thinker. It helps me think outside the box by giving me prompts of different ways to think about supporters. Another approach some people like to use is this, and there's a lot of different tools based on this sort of stoplight tool, where one would work through, and I know this is hard to read on the slide, but you have access to it, or you work through all the different components of decision making and particular decisions within daily life and employment, healthy living, and just navigating question by question. I can currently do it by myself, I need some extra help, or someone else has to do it for me. And the yellow and the red zones are areas that help us think, okay, what can we do to build in supports for the person so that they can get their needs met, and so forth. And I see we've got an answer or a conversation from Katie to Jess on the chat, so that's great. Another, charting the life course, and the charting the life course is heavily referenced in the Minnesota Disability Hub, but here's some examples of worksheets. What has happened before, how do we move forward? What's the vision for what I want and how we're going to get there, and for the person to articulate things they don't want. And if anybody has had exposure to person-centered trainings, what you've learned, or what you can think about in the context of this, is when we understand the individual, what's important to them, where they live, how they spend their time, their self-expression, who they're involved with in relationships. When we understand what's important to a person, we can understand that, and we can bridge that and use that to help also get to arranging for things that are important for the person: health, safety, well-being, basic needs, etc. Again, tools, tools, tools. This is from Charting the Life course. And again, you'll see it looks a lot like that stoplight tool I showed earlier. I've referenced a couple times Guardianship Information Line, which is a service that my office hosts. It's statewide, it's free, it's in-depth consultation, email, phone. It's toll-free if people still use landlines, local or cell phone. Call the 952 number. All gets you to the same place, trained, experienced social workers to talk about guardianship, decisional issues, supported decision-making, etc. So again, supported decision makings might sound like a new or foreign idea when you first hear the word or the phrase, but most families and people with disabilities and advocates, professional supporters are already doing it, even if they don't call it that. People without disabilities are using supported decision making. Anything we do to help a person with or without a disability understand, make, and communicate their own decisions. And it's going to look different for everyone. No court involvement, better chance of preserving familial relationships, less expensive, whether it's expensive to the family directly or to society, to our public dollars. We tend to have better outcomes for the person. It can accomplish a lot of what guardianship can accomplish. And we're required by law to try it first. And we can always, as I say in the last bullet point of the next slide, guardianship is still an option. It's there if you need it. But wouldn't it be great if you didn't, if we could try other options, especially when we think about the potential harms that can come with guardianship, the limitations of guardianship, when we understand the benefits of self-determination and what it means to be able to live a life that maybe does have some risk involved in it. Maybe I don't have the world's best diet, but doggone it, it makes me really happy that I get to have my candy bar every night before I go to bed. Maybe somebody would say that's really bad, but it makes me so happy, and I'm going to be really miserable if you take it away from me because of my diabetes or my cholesterol or my weight or whatever, right? That benefits of self-determination. We can address safety and vulnerability concerns even with supported decision-making from all the different options we've been talking about tonight. We want to think about, is safety the only goal? And can guardianship actually even accomplish total safety? And again, if we need it later, guardianship is still there. I like to leave people with these last two images, or this phrase on this image from the disability rights advocate Robert Persky: to deny the right to make choices in an effort to protect people with disabilities from risk is to diminish their human dignity. That's what the dignity of risk is all about. Jenny Hatch is the young woman in the foreground, a young woman with Down syndrome who is sort of the poster person for supported decision making. She's that's in the background with the sign of victory is her attorney, Jonathan Martinez. They worked together back in the mid-2000s, the 20-teens, to get her out of an overly restrictive guardianship and into a supported decision-making arrangement. And she's really, her story was covered a lot in the media, and her attorney, Jonathan, who's a very charismatic attorney, really elevated the idea of even people with pretty significant disabilities can do just fine. In fact, more than fine without guardians, acknowledging I need some help, but I don't need a guardian. Again, our information line, if you make your way to our website, I mentioned earlier, we have lots of information on our website about guardianship, about supported decision-making, links to external sites. I mentioned we also made a series of videos about supported decision-making, just very brief, 3 very brief videos that total less than 8 minutes each. They're like a couple minutes long each, but do a nice job of explaining guardianship in Minnesota and supported decision making. We've also published a couple booklets available for free download on our website. Please feel free to download them and share them, particularly the newer one, Best Practices in Supported Decision Making, aimed at families, how to be an effective supporter. And then all the things I've been talking about today, resources for you, links for you to the National Resource Center for the Brainstorming Guide, how to make a supported decision-making agreement, the Missouri Stoplight Tool, the Charting the Life course, minnesotacourts.gov, and then go to, you can, once you get that far, you should be able to click on, oh, it's not a live link. You should be able to enter in your search engine, minnesotacourts.gov, and then within that do a search for guardianship forms, and it'll get you to information about guardianship as well as the forms. I've given you a handout of the Bill of Rights, but here's the statutory reference. Again, the National Resource Center, I guess I've given you that on almost every slide. Minnesota Courts has a really great online training about guardianship, conservatorship, and less restrictive alternatives. There's a national training. Information on the Working Interdisciplinary Network of Guardianship Stakeholders website, as well as, again, here's the link. It's a live link to the courts right here. Whoops, I should put my mouse over on the other screen here. minnesotacourts.gov, there you go, to get to the forms. More articles on supported decision-making. A position statement by the ARC. I haven't been using this as much lately, but I thought I'd leave it in for us tonight since Donna and the ARC and a couple ARC people are here with us. Way back when supported decision making was first emerging as a concept, and a lot of us hadn't really heard of it, the AAIDD and the ARC came together and issued a position statement in support of promoting supported decision-making as an alternative to guardianship, as well as the National Guardianship Association. Jonathan Martinez, who I mentioned earlier, did a series of videos for Minnesota on supported decision-making. Those are available in partnership with Wings and DHS. Little bite-sized chapters. You can just peruse. You can hear more about Jenny Hatch, the young woman I talked about. You can learn more about the benefits of self-determination. This is a great resource list on YouTube. I talked earlier about concerns about sexuality and healthy relationships, and can people with disabilities really be engaged? Can they understand relationships and sexuality and intimacy? There's some great resources out there. One of my particular favorites is Elevatus Training, and I just did a screenshot from their webpage. They do a lot of evidence and trauma-informed curriculum, online training, services, workshops for professionals, educators, individuals themselves and their families to understand healthy relationships, even for people with significant disabilities. It's an excellent resource when we're concerned about care and safety. I've been mentioning the Disability Hub, disabilityhubmn.org, great resource on supported decision-making and guardianship and independence, as well as all the other things you all have been asking me about that I've had to say I don't know the answer, waiver services, etc. So that's a great resource. I've mentioned Wings. If you want to become involved and know what's going on at the state level in these arenas, you can get added to our newsletter listserv or mailing list. So you'll receive newsletters, webinars, etc.